Hi everyone. Can you see it? Can you see the little bits of fall peeking out over there? I can. I can definitely. Since there was a big misunderstanding where somebody thought that I was doing something that I wasn't, and my name got used, and the people on my hate train jumped on, and it was a big old mess. And then people were like, "Oh, is she the one who does the Katie Joy stuff and goes to the courthouses?" Well, yes, I am. So if this is your first time to my channel, thank you so much. And if this is your second time to your channel, please sub and like. And if this is your third or you've been following me from the beginning, thank you so much. You don't know how much your support means, because when I had all of the people on my tail that were telling me that I need to quit my channel, that this isn't for me, that clearly, I'm not strong enough, that I should get out and touch the grass and look at the sky and all that. Well, you know what? I do, and I do often. So if you looked at my content and saw that, I do. I'm actually probably outdoors more than most. Now, I should not be due to my severe allergies and the fact that, as I've shared with you, I can go into anaphylaxis from heat and ragweed together, but I am heavily medicated with allergy meds. So I'm here on the border of a beautiful prairie, and that borders several trails. It's a beautiful park that has archery, shooting, all kind a shooting range, archery, nature trails galore. So I hope to be here quite a bit in the fall, and I just kind of drive here and let my big kids go and hike for hours, and I do things. I actually do things, do my paperwork and such. But I'm going to go ahead and do my my reading for my channel here today, even though we are in a heat advisory. So I am risking my life to do this, to prove to you that, you know what, I can keep my channel. I did not do anything that I was accused of. The way that it came off, it was just really weird. It was just something that somebody read differently. It's a mess, but I didn't do anything, and I know that everybody wants to find a way where it was my fault, but I was just simply doing my own thing. I had actually made enough salsa for a year. I put the recipe up. I did end up putting my salsa through the blender that I had. The blender that I have is almost like a food processor, and that it can also chop. And so I did that because I just kind of feel like sometimes when the salsa has too big of chunks in it, and you freeze it, then those chunks just kind of can be kind of mealy, if you will. So put all that salsa through the food processor / blender, and then put it in freezer safe containers that I have, because I was a Tupperware lady, as y'all know, because I sold enough Tupperware to earn enough Tupperware to get myself enough Tupperware to reorganize and do everything nice. That being said, I still have more lids than I do containers, no matter what. No matter that I started and I had every single thing matched with a lid. How does that happen? Where do Tupperware lids go? Say that 10 times fast. And as y'all saw, this is the Charlie Brown kite eating tree. Beautiful little kite there, stuck up in that tree. But if you look and you see that one right there, it looks like that one, it might have gotten a lightning strike back there where it's kind of dried up. But to me, that just shows a little bit of the fall. It is overcast today and about 90. Oh, it's steamy. It's actually the kind that's best to get a tan, if you will. But just everything here is just so beautiful. This is a natural prairie and wetlands area. So all that you see here is natural. Now I'm going over to the picnic area. Now, there are some yellow jacket nests, so when I've tried to record here, I've gotten a little creeped out. So what I did is, when there's some spider webs and stuff, y'all know I love Bath and Body Works. So I have this. It's their version of stress relief, and it's eucalyptus and spearmint. Insects like mosquitoes and yellow jackets, even bees, I think, definitely spiders, do not like eucalyptus and spearmint. I love them. My cats don't like them. So it's also something that cats don't like. I know that somebody's probably going, you know what? Citronella does the same thing. I hate the smell of citronella. So this is the way that I keep insects away when I'm out, trying to do some work or whatnot while I'm waiting for my my family to get off of the hiking trails and stuff that I can't go on that are just a little too steep for me in my neuropathy. I have this on, but I have this as a backup. So, I took on a yellow jacket the other day. He was trying to get my groceries, and so I had to fight the yellow jacket off. And it looks so ridiculous when you're outside in your driveway fighting a yellow jacket because no one can see the yellow jacket that you're hitting. But you all know what I do if I start whapping at it. Now, have you guys spied this? Are you guys just absolutely wondering what this is? Okay, so I wanted the big one from Bath and Body Works. It was this on a stand, but it was $69.95, and your girl here doesn't have that kind of money. So I got the little tiny mini version of it, which holds hand sanitizer. So it's a hand sanitizer holder, but I thought it'd be just perfect for us to go in our crystal ball. And look at this, these witch hands. If you've seen the movie Wicked, or the theatrical presentation of Wicked, which I've seen twice, I think of Elphaba. When you see that, anywho, a little breeze is just enough. In the dark, you can see this better, but this little button makes the light go through it. Watch this. Okay, I don't think you can see it. Darn it, we're going to have to wait to show this one off in the dark. Because the light goes through and you can see it goes past it's, spirits and visions in this crystal ball. It is so cute. So yes, here I am, trolling without a crystal ball in the best possible ways, because the crystal ball things that I'm getting to do this, you all have seen, are the cutest, and I love to decorate for a theme. This week in my home, as it is September 1, I'm deep cleaning it all to get it all clean, and then I'm going to do fall decor, just purely fall decor, and then in 2 weeks I will add in the Halloween decor. And then after Halloween, I keep it up for maybe a week, and then I take away the Halloween and I incorporate back the Thanksgiving to some fall, and then about as soon as I can in December, which I like to be sooner than December 15th, but often it happens December 15th. I'm going to try and be a lot earlier this year. Then as soon as I can in December, then it goes all Christmas and all of the fall gets put away. My husband shared with me today about how he does not like how much I decorate, but that's okay because he's just sitting there watching sports anyway, while I decorate around him on the couch. Okay, yellow jacket, that's right, you go. Okay, can I not have you? There you go, see it? Did you see that go by? I love this. Just so cute. And this was only $7.95, and I got a 25% off coupon, so I think I paid $5 on this. I love this. Now this is going to go there. This is the self-portrait of me. This is what I look like, if any of you wonder. I don't have purple hair. It was blonde, like in the picture where I had my extensions. I don't have extensions anymore. And since the pandemic, I was able to grow out my natural, so my hair is not black. Maybe dark brown. So I don't have purple hair, but between that, that's pretty much the only difference. I am like this, and my witch hat actually has feathers. I think I'm going to add some rhinestones to it too. Why not? So anyway, I have a really cool witch hat, just saying. And then on the edge of the table, look at that. I have a crystal ball. A crystal ball right there. Because, Katie is without a crystal ball. I am collecting all the balls. So I'm going about this with all the balls. Going forward, trying to figure out everything. Giving you as much access as I possibly can to what is going on. With what is going on. in chapter, so before we go right to part 12, I want to talk about something that was noted in part 11 that I mentioned and wanted to talk to you about. So in part 11, where we had the defendant's memorandum of law supporting motion to compel and opposing motion for protective order, and that was written by one Jennifer Moore, the female attorney for Katie Joy. Now, in the back page, well, no, that's not right. The wind did just pick this up just a little bit, so let me see here. Okay, on page 10, so one of the last things that I read, and I kind of was like, oh, I got to figure this out. You guys might have already spied it if you just saw it in my paperwork. What I'm going here for is right in here. We go to this paragraph, and it says, plaintiff's memorandum supporting its motion for protective order does not identify the material that they characterize as their personal contact information. The material that plaintiffs can claim defendants posted about another case consists of a few pages of trial testimony, a page of deposition testimony, and what purports to be a witness statement of some kind. And that is apparent in Stavig, declaration in her Exhibit P. It says, there is absolutely no evidence that these materials were subject to a protective order. Okay. Now, and you can just hear Katie Joy saying this. So probably her attorney called up and was like, okay, well, what are we going to do about this? Because they say this, and, you know, this is kind of concerning. So what are we talking about here? Now imagine, because this is probably exactly how Katie Joy stated it, because she said, they are public documents available on PACER. Okay. So she's probably like, what are you talking about? Those are public documents available on PACER. OMG. Okay. Can't you even imagine it? And then it says defendants did post that discovery is about to get real. Defendants did not post that they intend to post sensitive information they gleaned through discovery on their social media accounts. Well, when she said defendant's post discovery is about to get real, can't you imagine? She's like, hi guys, yeah, well, you know what, I'm going to tell you that, you know what, discovery is about to get real. That's exactly how she would have said it. What does that imply? I can imagine that this piece is going to be very, very much analyzed if this goes to trial. They're going to say, well, you know what, you say that you wouldn't have used this information, that you're not trying to do this just to get information, that you're not trying to put 7M all the way through this just so that you can get information, just so that you can profit, and so that you can write out a little check in proportion to what you make from gleaning that information. What exactly did you mean, Ms. Mansky-Paulson, when you said discovery is about to get real? That's how this could go. Now, the way that it goes here is it says defendants did not post that they intend to post sensitive information they gleaned, okay? So would she say, well, I wasn't going to put sensitive information. Well, then we're going to go into that line of questioning. We'll be like, well, what is sensitive information? Is sensitive information somebody's home address? She'd be like, well, yeah, because what? You don't like it when people post your home address. Is that correct? Well, correct or not? But you don't like it when people put your, in fact, you've accused anybody who uses your address as being a stalker. Well, they would. So you would agree that posting somebody's address is sensitive information? Well, when they're trying to, so you would agree. But we will take that as a yes, Your Honor. That's how this could go. Okay. Now, says parties to defamation suits are entitled to obtain discovery that is relevant to the claims asserted in the pleadings. Okay. And it says defendants are entitled to obtain discovery as to plaintiff's claim that the statements made by defendant were false. Okay. Now, let's go here where Jennifer Moore says, assuming, and it says arguendo, okay, assuming arguendo, that despite the complete lack of showing good cause, the court finds that a protective order is appropriate. Such an order should be narrowly tailored, consistent with defendant's right under the First Amendment and the need for due process. Okay. Now, Amber Stavig absolutely pointed out in one of the last motions that we saw where Amber Stavig agrees that we have the First Amendment, but that is not a license to go and be reckless. And that's where we're going to have to really analyze and see what defines reckless. And they will go through that process and say, you know, what this is. Now, further says, defendants must be allowed to participate fully in the discovery process and provide meaningful assistance to their attorneys. Okay? Now, that's where a lot of this just kind of word salad went through to say this part here. She could have probably just put this page here and been fine, but all of the other case law and stuff needs to be, you know, referenced and cited. And then we go here to the conclusion where it says, for the reasons stated above, defendants' motion to compel discovery must be granted and plaintiff's motion for a protective order should be denied. And that's where she respectfully submitted that this last October 31 of 2022. So, you know, we're approaching that year mark where this was all taking place, and that was signed by Jennifer Moore. And what I wanted to produce to you here in my exhibits is when I was getting my undergraduate in criminal justice in the Law and Justice program, we had access to LexisNexis through our tuition, and I loved LexisNexis. LexisNexis is basically a court database, something that private investigators would use to track a subject, to try and find where somebody is, more to find out their criminal history, and patterns of behavior, okay? Journalists use Westlaw. I think we also had Westlaw I went to a few colleges when I finished up, so I think Westlaw was with the same college. I had LexisNexis. I like LexisNexis better than Westlaw, I think, just because I had started on it, but then you get into PACER. Now, PACER was one that I didn't like because I've been a broke hoe for generations, you know. Generations of broke whores are my legacy, and now I am one broke whore too. Anyway, I don't like to have little things where I have to pay here and there. I think that information can be sourced for my needs, definitely personal, through going to the courthouse in my area if I need it. And in 1988, that was the spirit of the laws that were passed that went ahead and did PACER. PACER is what was just identified here as what Katie Joy uses in a manner that would have to be identified to see if it's appropriate. This is my application to PACER. I did not submit this. This was done 7/25/2022, so over a year ago. If you do not put in a credit card when you apply to PACER, they will send you this, and it gives you a code then to go back. So it's not necessarily that they are verifying your address in that manner, like AdSense likes to do. They really like to look and be sure that your driver's license is correct, et cetera, that your address is appropriate. Basically, so if you're doing something you shouldn't, or if there's, a threat to your life, or you're threatening somebody's life, and somebody calls in, then they can get a hold of where the creator is, their address, rather quickly to local law enforcement. Now, with this being said, PACER is public access to court electronic records. The spirit of PACER was that people should be able to view everything that is going on in our federal court system. PACER is specific to federal courts, not your local courts. When you want to find out a person's pattern of behavior, you want to find out things that have happened in other lawsuits at the federal level, And a private investigator, a journalist, a real journalist can go to PACER, and a journalist going to PACER would go and see, oh, okay, well, this person has been convicted 5 times, or this person, was also in a similar lawsuit, and the lawsuit ended in this or whatever. And a true journalist will find the facts, weave it into a story that is captivating to listen to, and then insert these facts. Now, a Katie Joy just goes and sits there and is like, hey guys, well, look at this document. Yep, yep, you know who that is. Yep, hey guys, look at this. And she will lead with that nugget of information that she got there. That is, by law and definition, how you get yourself set up to be in the trouble that she's in. Now, my haters came for me and said that I embellish the truth and I go too hard for people. Well, I go, if you want to consider me going too hard for Michelle, that's your own problem, because she had her kids her parental rights terminated for a certain reason, and I'm not going to discuss that right now. And the ways in which she has done some other things are really disgusting, and the way that she financially exploits elderly people, veterans, her own child, the ones that don't have restraining orders against her, and she abuses dogs on her channel. She abuses animals on her live. If you want to call me going hard, fine, I'll take that. You want to say that I'm embellishing the truth? Yeah, that's because I'm not trying to be having my name on a lawsuit like this, because what you do as a journalist, as a creator, is, like I said, you get this and you go there. Now, the Watts case in particular, in the way that I felt when I looked through all of the information on both sides and put forth some of the backstory and actually then the full backstory of what was going on and how this situation reached a fever pitch, and whatever happened that night is disgusting and horrible, and absolutely the person responsible is where they need to be, in prison. However, he had a right to his day in court, and the actions that made him become that way are yet to be proven, and I believe that I did a good job in illustrating how that happened, when that happened, and that he had a defense that could have been very much used. Does that defense give him a get out of jail free card? No, not at all. It's not an OJ situation where, oh yeah, the glove doesn't fit, so he must have quit. Not at all. It's that he blames himself as much. Even if what was proven could be proven, he had at least temporary insanity. You would have to then tease out, does that equal life in prison? So, in the Watts case, where the family is very litigious, I worked very, very hard to say in the beginning of a lot of my content that, hey, I may be talking about them or I may not be talking about them. This may be a story about somebody else down the block, or it could be about the people that you think that it is. And some of the names have been changed, and I even changed names to create a story. I said that, her father was a strong, controlling Italian man. And what do I get? I get all this stuff. No, he's Polish. You don't know anything because he's Polish. I'm like, I'm creating a story. I'm creating a vision. I'm saying that because you don't really think of the strong Polish man being that kind of man. And maybe they are. I don't know. I just have not seen too many. But, as my dad is Italian, and I come from an Italian family, I can tell you that that's what I saw in them. And her mother is Italian, and so maybe some of that behavior, was being mirrored by her father. So I created the story. Now, what Katie Joy does is says the name of the person, says the show they're on, and then shows the court document in which she procured from PACER. That is scary. I would not do that. I don't think that there's very many journalists who would, because you're always towing a fine line in being sued for slander and libel. Every single person that was saying that about me. When I look at their thing and see that they're not a creator and they have 1 or 2 subs, they've not been in my position, and you don't know what you're putting yourself out there for. When you put yourself out there for this, and you want to, take a chance, you're not making money. Like I said, I've made $340 for 16 months of work now, total. I bought a laptop because my phone can't hold the videos. I'm doing more and more on my phone because sometimes the microphone doesn't work in there, and I bought that microphone too. So I bought a laptop, I put in the money for the blue microphone, blue snowball microphone, and I paid for Scribd, which is also a subscription, which sources documents. I paid for that, and I'm stuck in it like for a year now, I think, because of how I procured the deposition for all of the Watts case and everything like that. You can pause your membership, but in order to do that, and I also sourced the other for Shankella. I also sourced her documents through PACER. So I put in almost $2,000, and I've made $340. So I'm doing this because I believe in the truth, and I believe in the truth being accessible. That ties into PACER. PACER was created in 1988 because of the fact that people didn't understand what was going on in the federal courts, and it was very much a separation of the people in the courts, which is not what we want. So PACER was created. Now in here you can see, and this was dated 2022, which is also significant, because in here you're going to see that all registered agencies or individuals are charged a 10 cents per page fee for access to PACER. Statements are generated and distributed quarterly, and payment is due each quarter. Further access to the service will be restricted until outstanding balances are cleared. By logging into PACER, you acknowledge that you've read, understood, and agreed to the terms and conditions on the reverse side of this letter. If you have any questions regarding your account, please contact the PACER service by phone at, okay? Now, this 10 cents per page, basically there's a lawsuit out there that came about, and I think it was for users from 2010 to 2018, I think is where it was, that this multi-million-dollar lawsuit was filed because they argued that if information is supposed to be available to the public, why is the public having to pay? So I don't know if there were more fees associated, and this 2022 is the new fee agreement where it's just 10 cents per page that you access, or not. I need to find that out, but if you did use PACER prior to 2018 and you have not been a part of the class action settlement, you might want to see if that has if all of those funds have been given out, or if you might be entitled to a refund as well. The only other thing on the other side is it really talks about the fees and the importance of doing the fees. And it says here, users who provide a valid credit card or debit card at the time of registration will receive immediate access to court records. Users who do not provide a credit card number during registration will receive an authentication token via U.S. mail in 7 to 10 business days. So this would be my authentication token, and I redacted where it gives me that code and my personal identifiers. Now it says here, the PACER account being registered is for my use only, unless specifically designated otherwise on the registration form. I am responsible for preventing unauthorized use of the account. And you're supposed to call right away if you don't. Now, this is also important. It says usage is billed on a quarterly basis. Pursuant to judicial conference policy, fees are waived for usage of $30 or less in a quarter. So I think that means that if I don't hit that $30 mark, if I use this and then, they can see that maybe I'm using this for one court case or whatever, then I'm not using this as a business. I'm not, a real journalist, then they can see that and maybe it's waived. Who knows? I need to get back into that. Nonetheless, I will post an article showing how journalists source their information through PACER. I will put that on my community post, and I will put that I discussed this in this episode where this addendum to 11A is. With that being said, I'd like to advance towards part 12. And we will put that there. And we'll put that here. And let me check the time. Okay, I'm doing good. Okay. Let me wave around a little bit more like eucalyptus. It seems like the yellow jacket. I hate yellow jackets. They're just straight out of hell, you know. They have bit me and mosquitoes bite me. Ugh. Whoa. 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 No. No, 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 no. No. Stay here. Knock it off. Knock it off. Knock it off. All right. I'm just simply trying to defend myself against all of these things. All right. Let's see here. Okay. I'm probably sounding to somebody else like I'm being violated or something. Like, no. All right. So what we will do is we will put the unused documents in over here. So I will not need them. We'll take a puff of the inhaler to make sure that I can breathe. Inhaler, I'm not huffing or anything else, just so you guys can see. I think I've had an inhaler in my pocket. Are you excited to see me? Or is that an inhaler in your pocket? I think I've had an inhaler in my pocket probably since I was, 5 years old. I've been admitted for my asthma countless times in my life. Got a lot better in my 20s and then just got worse again. All right. So we are employing all of these things to keep our paperwork straight. And let's see here. If you guys didn't already know, you guys should have known to like go and get yourself something to drink and whatnot so you can get comfortable. Remember, mine is mine is a listening channel that I am not talented. I don't know how to do things very well. So mine is a listening channel. So put your headphones in, or listen to me while you're driving, sleeping, gardening, showering, whichever you like. Okay. And I do most of my things in playlist form, so you can turn them on and then they should just keep playing. I add each episode to the playlist as I go. Do you hear that? That's a cicada. Did you just hear that? Okay. Here we go. So 11 has an addendum, and then 12. So here we are in the state of Minnesota, county of Wright. Yes, we are. Actually, yeah, this park is in Wright. I was thinking it's in Wright. Talking about the judicial court, 10th Judicial District. Now, this is a memorandum of law opposing plaintiff's motion for a temporary injunction. So, of course, this would be written by... Oops. We've got Jennifer Morgan. Now, this one is dated November 4th, 2022. So just 5 days after the one that she wrote this. So what happened in those 5 days? Maybe I'll find something that was from Amber that we didn't see. Or this is just the second effort at them trying to block. I don't know why they would try and block the protective order. I mean, things that are under a protective order are so that the other person doesn't have access to make them further vulnerable. The damage that would happen to Shekinah Church and 7M because of what she does. It's totally different. Now, I know that in the comments, thank you so much for telling me that I was not saying Shekinah correctly. I think that I'm saying it right now, Shekinah. I think I'm saying it right. And I am not implying that 7M is the church. I understand that they are separate. The way that they are looped together is not my creation. It is Katie Joy's. And in so doing, it is no different than when she refers to the sister wives, polygamy, and the Mormon church, where the Mormon church does not support polygamy. And in fact, at General Conference, it has been stated several times that you follow the laws of the land in that. Katie Joy lumps it all together. And so when I am talking about this, it may be lumped together, but I am very well aware of the separation of it. I appreciate the insight that has been given to me about Shekinah Church, and Shekinah Church, and I would love more. If you can send it to me at tabithajane0@gmail.com. I'd love to know all that I can so that I can understand more where this is coming from. I personally do not think that it is a cult. I have not seen information that leads me to believe that is truthful and reliable. So I know that when you guys come from me, you guys think that, but just come on. I'm reading this. I'm going here. I'm trying to make this story interesting. So it's not like plaintiff's motion for a temporary injunction. Okay. Is that what people want me to do? Would I get less haters if I did that? Yes or no? Answer in the comments. I'll do it, Molly.
Place a 2 in the comments. I gotta get a granola bar.
Okay. So Jennifer Moore is stating here, as we have our plaintiffs and our defendants, the plaintiffs are 7M Films Incorporated and Robert Shin, and Miranda and James Derrick. I understand it does not say the church. Now, remember in that last thing that I said, in 11, it asks for all of the church's tithing, all of the amounts of man of God and first gifts. They lumped the church inside. They lumped it. So although it doesn't even say the church, you saw in that last complaint how they lumped that all in, that they want the church in there. So it's very much interesting, and I think that needs to be teased out as well. And we'll see if they do at some point. If it becomes a trial, and I know that you guys are thinking it'll become like a TV thing, it won't. Nobody cares about Katie Joy out here. Nobody knows who she is. She could walk by right here, and well, I would recognize her because I've seen her. She has a very distinctive look in her face, but nobody else would. Nobody else would be like, "Oh my God, that's Katie Joy." Nah, not even. She needs no bodyguards. The troll that came into my live said that she is hot and they want to be kidnapped by her. So, everybody's got to have something to hope for, I guess. Unless that was her husband or her. The introduction states, with the defendants being Catherine Mansky Paulson and Without a Crystal Ball, LLC. Plaintiff's motion for a temporary injunction must fail because it seeks a prior restraint that is prohibited by the First Amendment. Moreover, plaintiffs have failed. Look at this. It's missing another word. Great. I got to get my pen out. It's hard to read these because of the missing words. Does anybody proofread anything anymore? Should say the word "to" in here. Because it says right here, moreover, plaintiffs have established an entitlement of relief. Should be, plaintiffs have failed to establish an entitlement of relief under the Dahlberg factors in that. Number one, plaintiffs are public figures who are subject to intense media scrutiny, while defendant Paulson is a journalist reporting on controversies about plaintiffs that are already matters being reported on by media. My little question of that would be, how many other people has 7M and Robert Shin taken other members of the media to task? Have they filed lawsuits on them? Maybe they have. Number 2, any incremental benefit plaintiff might gain by silencing a single media outlet is outweighed by the harm created by the prior restraint that would be imposed upon defendants. Number 3, plaintiffs have not established a likelihood that they will succeed on the merits of their case. This is where, oh my God, this is where this happened. This must be. Do you remember that clip that I put on my community post where it was about a year ago, and whoever that guy was said, oh, it's a good day to be Katie Joy, that the court has said that they are not likely to win, that, this might be it. Because if we go right here, and it says, plaintiffs have not established a likelihood that they will succeed on the merits of their case. Okay, this word not right here is huge. Plaintiffs have not established a likelihood that they will succeed on the merits of their case. Big sentence there. Big, bold sentence right there. Jennifer Moore is all kinds of bold today. Well, she was on November 5th, 2022. I don't know how she is now. Anyway. Public policy favors supporting defendants' right under the First Amendment. And number 5, plaintiffs' proposed injunctive relief poses significant burdens upon the court that it would be required to ensure that defendants' rights to free speech and due process are honored even where plaintiffs have proposed to assume the role of monitoring defendants' compliance with the order. Okay. What does Katie Joy care about the court and how much she's tying it up for other things that might actually happen? She doesn't. She gets her way. That's all she cares about. My opinion, not written in here. Anyway, prior restraints of free speech have long been deemed there you go. Prior restraints of speech have long been deemed unconstitutional except in the most drastic of situations. And now it says Near versus State of Minnesota, and New York Times Company versus the United States, and the United States Supreme Court said, any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. And that was when Bantam Books versus Sullivan happened. The government thus carries a heavy burden of showing justification for the imposition of such a restraint. Okay. I'm going to skip a lot of these numbers and whatnot just because it really takes away from the flow of what is meant to be said. Such a restraint must be necessitated by a compelling government interest and narrowly tailored to serve that interest. And that was found by the Globe Newspaper Company versus Superior Court. The thing that I fear when I'm looking at this is that even if they win, if 7M wins, it'll go to the Supreme Court. I think that that's very much a possibility. And 7M could be waiting a long time for relief. Let's hope that it doesn't go that way, but it wouldn't surprise me, quite honestly. Sorry, the wind just comes along just enough. You know how if you're in California, you know how like the Santa Ana winds do that? You like make your yard really cute with Christmas decorations, and then those Santa Ana winds just come and they knock over your decorations. I know, because I lived in Irvine. The Santa Anas are warm winds. They're no joke. Okay, so, ew, get off me, bug. Okay. Plaintiffs have not identified a single governmental interest to be served by restraining defendants' speech. Instead, plaintiffs cite 2 Minnesota District Court cases where defendants were enjoined from making social media posts. In Sajady versus Nygaard, Hennepin County District Court in September 7th, 2021, the parties to the litigation had some sort of personal relationship that resulted in the issuance of a harassment restraining order. The plaintiff was an author and a lecturer who produced materials related to meditation, spirituality, and self-help. The defendant was a private citizen who had a prior history of harassing the plaintiff and his family. He created videos, social media profiles, and documents with allegedly false and defamatory allegations about the plaintiff. Unlike the present case, that plaintiff was not a public figure. Okay, I get it. That should have had emphasis, because it goes, unlike the present case, that plaintiff was not a public figure. Emphasis. Moreover, that defendant was not in the business of producing celebrity news content like defendants are here. Well, if she did anything locally about anybody locally, they'd probably go and beat her ass. She goes for people that she knows can't get her. Anywho, let me sip that tea. Ooh, I just spilled the tea.
Okay.
Finally, the court's decision, while final as to the parties in that litigation, remains untested by an appeal. Now, when we talk about Ludgate, okay, here we go. Ludgate versus Affordable Granite and Cabinetry in Hennepin County, May 18th, 2021. That case that was mentioned, blah, blah, blah. Involved a former business associate who threatened to target defendants as employees and published damaging statements about the company if it didn't settle the parties as breach of contract. Parties as breach of contract, breach of implied covenant and fair dealing, bad faith, promissory estoppel, conversion, intentional infliction of emotional distress, and claim of delivery. Once again, there is nothing in that decision that suggests that Ludgate was normally in the business of producing internet news and gossip content. There is also nothing in the file that suggests that Affordable Granite and Cabinetry held status as a public figure. The court, in fact, distinguished between private and public defamation, noting that the imposition of liability for private defamation does not bridge the freedom of public speech or any other freedom protected by the First Amendment. Okay? Now, this is where we're going to get technical. Okay. And that's where she was quoting the thing where it was stump cheese versus Minnesota. So what we can see here is that Jennifer Moore did exactly what I was talking about in PACER, is that an attorney goes and they search Westlaw, they search Lexis, and PACER, and they gather all of the information about the person that they're going to sue. And they get prior court cases and everything about that defendant, and then they go into similar cases and case law, and they combine all of that into one masterpiece of a motion and put that forth, and then they do a lot more research for trial. So you can see this at work here. If the other attorney references, so as Amber said, hey, this is the reason why, and Stump G's and this cabinetry company, both show this as that, well, then Jennifer Moore would in turn go into PACER or Westlaw or LexisNexis and read those that case law and see how the decisions were made and what behavior was actually in there and what that lawsuit really entailed and how that decision was then
determined by the Supreme Court, and they would maybe be able to read the dissenting opinions of the judges, etc., to really get in there. And then that attorney would take their own talent and say, you know what, I see it differently, and I see that then they did this because of this. But you have the other attorney who say, no, I see that they did this because of this. Those two fight it out. The judge determines with their breadth of information and their experience on seeing both sides what they determine, and then you go further and further and further until you decide to come to an agreement, which is either an agreement or a settlement, that, you know, okay, I'll take responsibility for this, and to make you whole again, I will give you this much compensation to, you know, to make sure that is appropriate. Or it continues to go to trial, where a trial by jury decides, does this rise to defamation or slander, and was this other person affected? And it's going to be really, really important to determine who is a journalist and who is a public figure. Those definitions are absolutely going to be pivotal in the trial, I think. So there's my dissent. Now I'll keep going. Plaintiffs have failed to overcome their burden to justify the imposition of prior restraints, such that the court could even entertain the Dahlberg analysis required for the issuance of injunctive relief. Okay. The Dahlberg factors do not even weigh in favor of the injunctive relief. Before issuing a temporary injunction, the court must apply the factors set forth in Dahlberg. And Dahlberg includes the Brothers Incorporated versus Ford Motor Company in Minnesota. Now, we're going to talk about this, and this is repetitive because we just heard it in the other. So Dahlberg states here, we're talking about the Dahlberg factor, okay? Dahlberg factors. Dahlberg factors state, number one, the nature and background of the relationship between the parties pre-existing the dispute giving rise to the request for relief. Number two, the harm to be suffered by plaintiff if the temporary restraint is denied as compared to that inflicted on defendant if the injunction issues pending trial. The likelihood that one party or the other will prevail on the merits when the fact situation is viewed in light of established precedents fixing the limits of equitable relief. And number four, the aspects of the fact situation, if any, which permit or require consideration of public policy expressed in the statutes, both state and federal. The administrative burdens involved in judicial supervision and enforcement of the temporary decree. And then down here, a weighing of these factors does not yield the conclusion that injunctive relief is appropriate. And then we go to A, and it states that the nature and background of the relationship between the parties does not support the issuance of a temporary injunction. A temporary injunction is extraordinary equitable remedy, and its purpose is to preserve the status quo until adjudication of the case on the merits. In Miller versus Foley in Minnesota, 1982. The thing is that, here I go again, dissenting, my dissenting, here I am the judge here, I'm giving my dissenting opinion. These things that were determined were like in 1982. When they're talking about case law that was in 1982, that's before the internet, before social media, before the damage of social media, where people would have to still, go and buy that certain publication, go and look in that certain encyclopedia at grandma's house, and look up this thing to make their book report to find this and that. We need case law that's more pertinent and relevant to the damage that social media can inflict. And I don't, maybe it's not there yet. Maybe this is just really, maybe Katie Joy will set precedent. Maybe she'll be the ass of all social medias. Or maybe it'll be like, wow, to the Katie Joy standard, we all have freedom of speech. And we can be reckless as we want to be. Before this matter, plaintiffs were public figures who produced internet media content. Defendants produce internet gossip and news content. Okay. So we're going here, defining who these people were. So let's keep this too, because this might be pivotal. So let's set the stage. Before this matter, plaintiffs were public figures who produced internet media content. Okay. Defendants produced internet gossip and news content. I think that the word gossip is going to be really important to define as well. There is no contractual or familial relationship that must be preserved pending resolution of the plaintiff's lawsuit. B. The balance of harm does not weigh in favor of injunctive relief. Defendants have established that the requested relief is a prior restraint that infringes upon their First Amendment right to speech. Defendants will acknowledge for the purposes of this motion that the things being published about plaintiffs are unflattering and may lead others to believe unflattering things about the plaintiffs. However, defendants are not the only people saying these things. A Google search of 7M Film Shin yields 4 pages of results from content providers other than defendants. In the Paulson Declaration Exhibit B, none of these links are flattering articles about the plaintiffs. Although plaintiffs may prevent one journalist from publishing negative stories about them through injunctive relief here, plaintiffs cannot prevent the rest of the internet from following this litigation, investigating the claims made by defendants and others publishing unflattering articles. Thus, while injunctive relief may yield some marginal benefit to plaintiffs, overall the balance of harms weighs against imposing a prior restraint upon defendants' First Amendment rights. Okay, then. Plaintiffs have not shown a likelihood that they will succeed on the merits of their case. Okay, this is more of where that guy was mouthing off. And, for him to have mouthed off on a motion, and maybe the judge will say that, but we know that the protective order was put in place, so I don't know. Because it says plaintiffs have not shown a likelihood that they will succeed on the merits of their case. Defamation is established where a plaintiff provides that A, the defamatory statement is communicated to someone other than the plaintiff. Well, 2, that the statement is false, and 3, that the statement tends to harm the plaintiff's reputation. And that was found in Barr versus Boise Cascade Corporation in Minnesota, 2009. If plaintiffs are public figures, there must be a showing of actual malice defined as publication while knowing that the statement was false or with reckless disregard whether it was false or not. Stumpcheese versus Park in Minnesota, 1980. Defendants allege that the statements in question were either true, opinion, or subject to privilege. For reasons stated in defendants' memorandum opposing default judgment, there is a significant likelihood that plaintiffs will prevail to establish that defendants' reporting constituted actual malice, such as that they will be able to prevail on their claims of defamation. Moreover, defendants have missed their deadline to conduct discovery and may be foreclosed from performing the discovery necessary to establish actual malice. It simply cannot be said that plaintiffs have shown a likelihood that they will succeed on the merits of their case. God. I had to insert a couple of words to make that flow better, and it's still just... Okay. Let me see it. Let me try this in this one again. Where it says here, it simply cannot be said that plaintiffs have shown a likelihood that they will succeed on the merits of their case. I think that the word or should be in there because it just doesn't make sense. Establish or. Okay. Now, public policy weighs against injunctive relief. In defendant's cite, Miklovich versus Lorraine Journal Company in 1990, for the proposition that, sorry, a little thing is biting me, for the proposition that society has a pervasive and strong interest in preventing and redressing attacks upon reputation. The defendant stopped reading a little too soon. However, the Miklovich court continued. Judge Stewart in Rosenblatt put with his customary clarity that the right of man to the protection of his own reputation from unjustified invasion and wrongful hurt reflects no more than our basic concept of the essential dignity and worth of every human being, a concept at the root of any decent system of ordered liberty. The destruction that defamatory falsehood can bring is, to be sure, often beyond the capacity of the law to redeem. Yet imperfect though it is. An action for damages is the only hope for vindication or redress the law gives to a man whose reputation has been falsely dishonored. Far from supporting the proposition that reputational damage should be considered as part of a public policy analysis when considering injunctive relief, Milkovich stands for the proposition that money damages are the way to serve a public policy in favor of protecting reputational harm. The only public policy present in this case is that supporting... God, she makes this tough. Does she talk this way? Look at this sentence. This last sentence states, the only public policy present in this case is that supporting defendants' right to free speech. Okay. If I put emphasis on certain words, it works. Okay, then. I'm sure she never thought anybody'd read this, except for the judge. The judge must know the way this goes, but here I am sitting in a beautiful park reading this crap. Why? I have no idea. Because I think that the public needs to know what's going on? I guess so. Administrative burdens involved in judicial supervision and enforcement of the temporary decree weigh against injunctive relief. Plaintiffs posit that administrative burdens can be largely borne by the parties themselves. Certainly, defendants expect that plaintiffs will continue to monitor Ms. Paulson's every word on the internet. However, the administrative burden is not about monitoring defendants. Rather, the administrative burden lies in ensuring that the defendants receive due process should plaintiffs discover any perceived violations of the court's order. In fact, plaintiffs' proposed order demonstrates these administrative difficulties. The proposed order indicates that plaintiffs plaintiffs want defendants to be enjoined from publishing or republishing on the internet, websites, forums, blogs, social media platforms, or otherwise the following material regarding plaintiffs. Okay, so they want, 7M wants to be sure that Katie Joy stops saying these things. Okay? Let's go here because it says that plaintiffs want defendants to be enjoined from publishing or republishing on the internet, websites, forums, blogs, or social media platforms, or otherwise the following material. Plaintiffs, regarding plaintiffs. Okay. Now we're going to go here through A through J. Plaintiffs want defendant Katie Joy. So 7M and Robert Shin and Miranda Derrick want Katie Joy to stop saying that plaintiffs are associated with a cult, that plaintiffs are engaged in human trafficking, that plaintiffs are engaged in theft, that plaintiffs are engaged in sexual exploitation, that plaintiffs are engaged in torture, that statements that plaintiffs are engaged in kidnapping or holding people captive, statements that are relating to legal proceedings with the plaintiff, and statements regarding any relationship between plaintiffs and their business partners, employers, employees, or affiliates, and statements regarding the marriage of the plaintiffs and all other false and defamatory statements as described in plaintiff's amended complaint. All right. This next sentence is is hilarious because it says, although this list is very long, it is also very vague. Okay. I don't think that's vague. Here, why don't you stop saying that I'm doing all this? Just stop saying these terrible things and we'll be good. Oh my God. I don't think that's vague at all, but I guess I don't know. For example, while it might prevent defendants from stating that plaintiffs have engaged in theft, it might not prevent defendant from stating that plaintiffs were found to be in possession of property that did not belong to them. Similarly, it is not clear if plaintiffs seek to enjoin defendants from publishing the fact that human trafficking allegations have been made against plaintiffs, or merely the conclusory statement that plaintiffs have engaged in human trafficking. Is the word enjoy correct here? Look at this. It is not clear if plaintiffs seek to enjoin defendants from publishing. I don't think that's the right word. But then again, I'm going to have to define this word, see what my problem is, right? What other word would be right there? I think cease would be great. Like similarly, it is not clear if plaintiffs seek to cease defendants from or stop, but to enjoy. God. Oh. Like I say, I'm not a fan of Katie Joy, but I would be having a problem with my attorney not proofreading her documents with as much as, I don't know how much Katie Joy is paying her, but attorneys customarily are not cheap, and we see that she's paying out quite a bit in fees and whatnot. But this may be the only attorney in the state that will defend her, because I don't think that a lot of attorneys, is my opinion, that a lot of attorneys would want to take this on, because it's very dicey, it's very labor intensive, and I think that the question of why the attorney who defended her prior is not defending her at this point, it could be argued that that is problematic in that that attorney does not because the other attorney who defended her previously would be able to know her character, know what she does, and be able to defend her. If he refused in some way to defend her in this action, it makes me at least wonder why that is. If he says, look, you shouldn't have done this. I think maybe the attorney doesn't practice anymore. Maybe he left the state. Those things could be true too, and I guess that's what the other side probably looked at, probably went into her prior legal issues and found that. And now the one with Tati, of course, in order to save money, if I was Katie Joy, in order to save money, I'd be like, fine, if they want a protective order on that, that's fine. I'm not going to argue it. I want to get to the bottom of this. I want to settle. Katie Joy is not taking it in that way because she's stubborn as hell, narcissistic sociopath, in my opinion, from other narcissistic sociopaths that I've seen in this pattern of behavior that she has. To be most cost effective in the lawsuit that Tati filed from Washington State. The lawsuit was not easily, but in its most basic form, it was able to be thrown out due to jurisdiction, stating that it was not filed with the proper jurisdiction, and the judge agreed, basically, a very simple thing. If Katie Joy wanted to, take this all the way with Tati, it would have been like, okay, it's not in the right jurisdiction, so I'm going to say that, and I'm going to have a cause of action against you in my jurisdiction that you shouldn't have done this, blah, blah, blah. But as others have pointed out, because you guys are all so smart in the comments and whatnot, you guys have pointed out that in that thing, even though it was in the wrong jurisdiction, Katie Joy needed to retract her statements and take down the information or whatever it was that she put out about Tati, et cetera, et cetera. Katie Joy likes to see that as a win. I don't think that's a win. I think that Tati made a significant impact, and right now it's going to be here. No different than how Butthole Betty is getting taken to the cleaners right now over her. She really allegedly went after somebody else. Crude as something. Took him for everything last year, and he was not able to keep up with her pattern of harassment towards her family, his family, and et cetera, et cetera. And by the time all of the false allegations that Betty had put up, he just wanted it done, and reportedly he gave her a check of $500 to just tell her to go her own way. Okay? Now, she bit off more than she could chew and kept saying she's going to sue everybody who, dares to laugh at her, et cetera, et cetera. And she put up a defamation suit, and the community has come together to get her a great lawyer, and put not only to defend her, but to reverse the tables and sue Betty. The amount of information that Betty is going to have to put forth is enormous, and it includes all of her conversations of all of her associations and anybody who has worked with her, and all of her phone conversations, et cetera, on all cell phones, all computers, all of that for the past 5 years. So it's going to get involved into who has been, doing so much trolling on Betty's behalf and giving her these ideas to do what she is doing right now. So what happened with the crude as, like I say, it's crude as, I think it's crude as F. Tati was essentially crude as F to Katie Joy as crude as fuck was to the lawsuit in Queen Bee. Both cases before are affecting the bigger cases now. And sometimes that happens. that when the person doesn't reform their behavior, that they continue that pattern of bad behavior, then their prior acts will come into play. And although maybe they shouldn't be considered, if it goes to a trial by jury, maybe they'll be able to get the Tati thing thrown out, et cetera, et cetera. You'll have to find a jury that doesn't go on social media, which wouldn't be hard in rural Minnesota at all. And maybe Katie Joy knows that. Maybe Katie Joy knows that if it goes to a jury of her peers, no one goes on the internet, so they're not going to understand what is really going on here. Who knows? And she is rural. Very rural. So, saying that, basically, this sentence that doesn't make sense is as follows. And we see here. Similarly, it's not clear if plaintiffs seek to enjoy defendants from publishing the fact that human trafficking allegations have been made against plaintiffs, or merely the conclusory statement that plaintiffs have engaged in human trafficking. So she's saying that possibly a responsible journalist would say 7M has been accused of this, versus what they are saying Katie Joy did and saying that 7M engaged in this. All right, and now we are to page 8 of 9. We are making some progress here. Thank you for holding on in this rather lengthy episode 12 that included that addendum to 11. And now it says here, perhaps most concerning is the prohibition against republishing material. The internet is constantly being refreshed. Content is constantly being shared between users and websites. Defendants have control over some of this process, but not all of it. A content producer may write about plaintiffs and link to content previously created by defendants, republishing the material. Defendants can foresee plaintiffs bringing motions to enforce a temporary injunction alleging republication where defendants did not seek or intend to republish. Perhaps recognizing the administrative burdens posed by plaintiffs' preferred injunctive language, plaintiffs propose that defendants merely put a litigation disclaimer on every social media post or video. That also poses significant administrative difficulties on an internet where content is not always dated or properly attributed, especially when your sources don't exist. Katie Joy. Anyway, have a yellow jacket in my throat. In short, plaintiffs' proposed injunctive relief poses significant administrative burdens that cannot be solved merely by plaintiffs' assertion that it will be the web police for the court. Defendants are entitled to due process, and it will be the court's job to ensure that due process occurs. This factor weighs against injunctive relief. The conclusions are: because plaintiffs have failed to establish that the Dahlberg factors weigh in support of the issuance of a temporary injunction, that would be a prior restraint against defendants' First Amendment rights to free speech. The court must deny plaintiffs' motion. Again, that's dated November 4th, 2022, so almost a year ago, and it was respectfully submitted by Jennifer Moore, and she was representing Katie Joy Paulson, aka Without a Crystal Ball, for Troutman Martin Law. And page 8 of 9 and 9 of 9 is Wait a minute. Wait a minute. That's interesting. Why did this do this? Okay, so I guess that this 9 is this right here where it just shows, it says the attorneys for the defendant, Catherine Paulson. It says Minnesota Statute 549.211 acknowledgement. The party on whose behalf the attached document is served acknowledges through its undersigned counsel that sanctions, including reasonable attorney's fees and other expenses, may be awarded to the opposite party or parties pursuant to Minnesota Statute 549.211. And that's cited as being in 2016. Again, signed by Jennifer Moore, attorney for the defendant. That is our 12. And I just, in case you guys want to hang on for one more minute, I'll go back through the prairie just a little bit more. Because I love this. I think it's so pretty. Let me see here. I'll zoom out to the trees for you. Look at how gorgeous they are. And when they start just this little touch of fall, it goes fast. And then we'll get like a weird freeze. And then we'll get nothing. And then a freeze. And then it'll be back to summer. And then nothing. And then a horrible windstorm will take away all of our beautiful fall leaves. And then nothing. And then sogginess until maybe a couple little snowstorms. And then nothing until like February, March, when it should be spring and a lot of snow. So that's what's in store for us. The 9-month seasons of winter now. But I love these. I love these beautiful prairie flowers. And they grow naturally. This is just your beautiful prairie wetlands. The purple against the green is just beautiful. Hi, Grasshopper. How are you? Would you like to make a guest appearance here? There you are. Hi. How are you? That's there. And these thistles. Oh, look at this. Hello, Bumblebee. Hello, I'm not going to bother you. Hello. Look at how the bumblebee's so busy right there. Hello, beautiful. Yep. Take you right back. There you go. I won't bother them. They won't bother me. But I love this purple right here too. Now you have to be really careful when walking through these areas because there can be yellow jackets from hell. They come straight out of hell up into the earth, and they have piles, so you have to be careful when you walk around areas. And I wanted to show you guys this. This is so cute. It was this Eagle Service project that they made here in this park. So cute. So look at this. It's an area where you can have like a bonfire. We got grasshoppers here. You can have a bonfire here, and you can sit in this circle. Now, where I was at, look at that beautiful picnic area. And the picnic area has like an area for you to cook and everything like that. And then just down from this is here, so you can have a bonfire. And it's just absolutely beautiful all around. The trails go up all through there. There's a nature play area over there. It's really cute. And this is really cute. It's called this Slinky. Slinky the rock snake. Add a painted rock and let's see how long I can get. So somebody just added this. And so it's there. You can do this. I've seen other people do this under a tree and stuff. So if you like to paint rocks, create your own. And then people just paint a rock or bring it. So if you bring your kids and they see that, then they'll want to go home and paint the rocks and bring them to the rock Slinky. This one is my favorite, I think. Where it's got the leaves that they did. You got the head of the snake there. They did this big snake head. So you gotta do that. But also people will just create like a little painted rock park. or painted rock area in a park or anywhere. You can really do that. And then some will say take one and bring one, or just take one, and then it'll have like a place where you can go on their Facebook or whatever and say where you're from and where you took the rock. So that's just cute, I think, this little painted rock snake. Get the edge of the prairie. And this pretty much shows where we are in Wright County. And here's more of the prairie area. It's just all bordered by this natural prairie. Now, Little House on the Prairie was filmed here in Minnesota. An area a couple hours from here. Hello, look at you. I love grasshoppers. I think they're so cute. Why'd you hide? Are you camera shy? So when you see the beginning of Little House on the Prairie, and you see, well, I guess it was Kyle and her sister. Now you know them from the Beverly Hills Housewives, but they're like running through the prairie. They're running through a Minnesota prairie, something similar to this, but I think it was more of a dry prairie. This prairie has some wetlands pretty close to it, so it's a greener prairie. It's really cool though because it borders a vintage golf course, and then it has deep into the woods, you know, a shooting range, the archery area. Just a really cool park. Hope I'm not boring you guys, but I love this here because you can see these areas are where animals sleep at night. You can see when the grass is patted down. That generally means like a bigger animal like deer will sleep here. You can see all of this right around here. So deer, whatnot, will come. Yes, of course, some of that is where the grass is cut back. And you're like, oh, that's just cut back. Not necessarily, because look at how this is there. It's growing around it, and then you have the flattened area. This is wood then from this tree that people can bring right over and burn. And again, it said that that was part of an Eagle Scout project. Look at that. It's just beauty all around. And of course, these are all considered weeds. And here I am doing this, and I'm like massaging my sinuses and like assault on the sinuses. Now, this heat bubble that we're in, it's just the clouds are holding the heat in, and we're not getting a clearing. On my community post, I was blessed enough to be able to get a clearing so I could take some beautiful pictures of the almost full moon. The night before, it was actually the blue moon, and I didn't get it. It was overcast, and I just didn't get back up to look. But then the other night, when it was just beautiful, I just stayed up and did some work so that I could keep taking pictures of the moon as the clouds cleared. And oh, it did not disappoint. The moon was just absolutely beautiful. But look at the way that they've made this. It's so cool. There's our crystal ball area, our work area for today. Check this out. They made this with all of these beautiful, beautiful picnic tables. And this area for food prep. So couldn't you imagine like coming here for a birthday party, family celebration? Look at this, it's beautiful. If you're in Minnesota and you want to know where this is, email me and I'll tell you. But it's just cool to have a prep area so you can put like all your food here. These are, oh, they are plugins. You could put crock pots and like food warmers and stuff all right here. Look at this to keep everything warm. When I was young, they just had, I'll take you up to the archery area. They had, hi grasshopper. Hi honey. How are you? Hi cutie pie. What are you doing? They just had basically areas where they had just a little hole dug out and like a little grill. Do you guys remember those in the parks?
They didn't have anything else, and I remember my hippie parents actually using pine cones instead of charbroil. Oh, here's one. I'm walking around describing it. So this is probably what originally was there, and maybe they can use this as well. So you can just grill on these. These used to be all over in parks in the 80s. Now up here, I'm just going to zoom in so that I don't get anybody's privacy, but there's no one here. But anyway, the archery area is up there, so that then you can measure, 20 yards, 15 yards, 10 yards. Caution, archery in progress. Definitely. So you've got the archery area. All these trails lead in. There's several trails, and there's one called a prairie loop. And then the different trails all have different, can you imagine different areas where they go? I think the prairie loop might be one I can try. I might try that one of these days. Because when the fall leaves hit, I can't even imagine how beautiful this is going to be. I'll be here quite a bit then. If you want to know where I'm at, that's where I'm at. Look at that. Now, we have no rain in our forecast for the next 5 days, but I think that given the opportunity... Oh, there's dragonflies. Dragonflies, come here. Come here. I love dragonflies, you know that. Let me see if I can catch them. Nope. They went off just a little bit out of the camera. Are you guys coming to talk to me, you little dragonflies? Maybe so. Maybe they're coming to have a little chat. Yeah, when this is fall, when the fall leaves hit, I'll come here and I'll do more content from here. As much as I can. Get the fresh air that I can. So, if you liked this, please be sure to like and subscribe. If you want to buy me a coffee, please go to my Cash App at Tabitha Jane 13. It'll have a little picture. The little icon is a Boo Boo, my gray cat. I have 3, but Boo Boo is my boy, my little boyfriend, my little furry boyfriend. And that will get me the coffee that I need to have enough caffeine to keep this up. I am fueled by caffeine. Thanks for listening, and let me know what you think in the comments below, and I will talk to you in episode 13 in my narrated series of Katie Joy with an LED crystal ball, with many balls. Maybe I'll do many balls. Maybe I'll change it to many balls that I have. All the balls in the world. Kind of like what she has when she writes some of this shit anyway. Yeah. Anyway, thanks so much for listening. I appreciate it. Thank you. Bye-bye.